All right. Hi, I'm Kate Levine, and this is the inaugural episode of Cardozo Law Presents Unboxing the Law series. Together with my colleague, Kathryn Miller, we're going to discuss the recent Supreme Court decision in Flowers versus Mississippi, which was handed down on Friday. This case is notable for a number of reasons. It involves the death penalty, race, and 6 trials of the same defendant stemming from the same set of events. I learned over the weekend that it's also notable because there's a big non lawyer following. There's a popular podcast called In the Dark that a lot of folks have been listening to. Actually, my sister, who's not a lawyer, knew a lot more about the background of the case than I did. So suffice to say, there's a lot of interest in this case. I think among Supreme Court watchers, it's also known as the case where Justice Thomas spoke for the first time in 3 years. So I'm going to give a little bit of the factual background, which actually isn't particularly important to the legal ruling, but just for interest. So in 1996, 4 employees were killed, were shot at the Tardy Furniture Store in Winona, Mississippi. All 4 victims were employees of the store. And Curtis Flowers, a former employee, who at the time had no criminal record, no involvement with the law, was accused of the murders. The prosecution's case, which I've basically gotten from Justice Thomas's dissent in the Supreme Court case, was that on the morning of the murders, a .380 caliber pistol was reported stolen by Mr. Flowers' uncle, uh, taken from his car, and a witness claimed that they saw Flowers buy that car before the shooting. There were bullets recovered from the store that matched bullets that would be fired from that pistol, and a small amount of gunshot residue was found on Flowers' hand later. But on the other hand, there had already been a police report that someone had tried to break into the Tardy Furniture Store through a skylight. This was 8 days before the killing. Their 380s, the .380 caliber pistols were being used in robberies in that area throughout that summer. There was another .380 caliber pistol found near the scene. And experts have also questioned whether one person could possibly execute so many people so precisely in such a short amount of time. So a lot of reasonable doubt. Um, the case has also gotten weaker over the years. A number of witnesses have either recanted or had their testimony questioned. But as I said at the opening, this case is really not about those facts. It's about the way the lawyers selected the jury. So Mr. Flowers was tried 6 times. Mr. Flowers is African American. He's tried 6 times by the same white prosecutor, Doug Evans. Prosecutors and defense attorneys get some say in who's on a jury. They can strike, which means sort of get rid of jurors that they don't want. And Katie's going to explain this more in a second. But here in the first 2 trials of Mr. Flowers, Evans, the prosecutor, struck all the Black jurors but one. So this means 23 out of the 24 jurors in these first 2 trials were white. Both juries convicted and sentenced Flowers to death. These convictions were reversed by the state Supreme Court or state appellate courts because of the racial nature of the strikes. In the 4th trial, the prosecutor again tried to strike all the Black jurors, but because there was a larger pool, that jury ended up having 5 Black jurors on it. That jury deadlocked, which means they couldn't come to a decision. The case was dismissed, but the state could go again, which they did. So they tried a 5th and 6th time. The 5th time, a jury of 9 whites and 3 Black jurors again ended in a mistrial. In the 6th trial, which is actually what the court is considering, the Supreme Court is considering in this case, the prosecutor struck 5 of 6 Black jurors. So this jury of 11 white jurors and 1 Black juror convicted and sentenced Mr. Flowers to death again. But here, the Mississippi Supreme Court upheld the verdict. Mr. Flowers appealed, and that's how we ended up at the Supreme Court. So Kathryn, is going to explain that ruling and what it means for a line of cases called Batson. Take it away.
Thanks, Kate. Hi, I'm Kathryn Miller. I'm an associate professor of clinical law here at Cardozo, and I'm also a member of the Capital Defense Bar. So I've been watching the Flowers case and was very excited to see that the ruling came out in favor of Mr. Flowers. So specifically, the holding is that the trial court in Mississippi erred when it found that the prosecutor's strikes of Black jurors were not racially motivated. And so the first thing you need to understand when thinking about this case is that lawyers have different types of strikes that they can use to strike jurors. One, the first type is called a challenge for cause. And you as a lawyer have an unlimited number of challenges for cause, and you can raise a challenge for cause if you believe that a juror is unqualified. That's not the kind of strikes that we're talking about here. Here we're talking about peremptory strikes. Peremptory strikes mean that each side has a certain number of people that they can strike for any reason. Peremptory strikes are very old. They were traditional parts of English common law, and they've made their way to the United States and are usually prescribed by statute in different state courts. So you only have a certain number of them. And it used to be until 1986 when Batson versus Kentucky was decided by the court that you literally could use a peremptory strike for any reason, including a racially motivated reason. But in 1986, the Supreme Court said, no, in fact, the Equal Protection Clause applies to jury selection, that it safeguards the rights both of criminal defendants and of the jurors themselves, who have a right not to be excluded from jury service. And they developed a test to determine if the state was engaging in intentional racial discrimination. And that test is called the Batson Test. And the Batson Test is what's at issue here in the Flowers case. So the Batson Test has 3 steps to it. In the first step, typically the defense lawyer will make an argument that there has been a prima facie case of racial discrimination. So in looking at the pattern of strikes that the prosecutor has used, or looking at the types of questions that he has asked a certain protected class of jurors, you as the defense attorney can say, I think there's been a pattern in practice of racial discrimination. It makes out a prima facie case. Sometimes numbers alone are sufficient. So here, 5 out of 6 black jurors were struck. As a defense lawyer, I probably would have raised a Batson challenge after the second Black juror was struck by the prosecution, because it begins to show a pattern in practice. Once you have made that showing and the judge agrees that you've established a prima facie case, they kick the question over to the prosecution. And the prosecution then has to explain race-neutral reasons that she had for striking the jurors. Once the prosecutor has given race-neutral reasons, then it's up to the judge to determine the credibility of what the prosecutor said. And the judge can decide those race-neutral reasons were the actual reasons that the juror was struck, or the judge can decide that those were actually pretextual reasons for racist underlying reasons. If the judge decides that the reasons were pretextual, the Black juror is actually seated on the jury. If the judge decides that the reasons are actual, jury selection continues and the juror is dismissed. So that sounds like a decent test to try and determine if a prosecutor typically, but not always, is engaging in racial discrimination in jury selection. But in fact, in practice, the Batson test has been a pretty universal disappointment. And that's because both scholars and practicing advocates have realized that judges almost never challenge a state's neutral reasons for striking a juror. These reasons can literally be anything other than striking based on the race of the juror. So they can include things like the juror's affect or the juror's demeanor, the way that the juror dresses. They do have to be able to articulate some reason that their intuition says this isn't the best juror, but typically the judges give them a very broad brush to do so. And part of the reason that judges don't tend to challenge the credibility of prosecutors is that these prosecutors are repeat players in their courtroom. So judges and prosecutors, particularly in a small town like Winona and Curtis's hometown, they all know each other and they have relationships. And in making a Batson finding against a prosecutor, the judge is essentially saying, you did something racist. Judges are reluctant to do that. And so in reality, criminal defendants very rarely win Batson trials, or Batson challenges, excuse me, at the trial level. And sometimes, you know, upon the review of a cold record, like in this case, an appellate court might overturn the trial court's conclusions, but it's actually quite rare. But that is what happened here. Judge Kavanaugh, in evaluating the evidence of the prosecutor's pattern and practice of strikes through all 6 trials, also in the 6th trial itself, in looking at how the prosecutor treated the Black jurors who were struck versus the white jurors who were actually selected to serve. He compared individual juror characteristics to one another, and he also looked at what's called disparate questioning. So Kavanaugh noted that the prosecutor asked an average of 29 questions to the Black jurors that he struck, but an average of only 1 question to the white jurors that he kept. And so as a result, it became clear, Kavanaugh said, in fact, that the trial court's holding was clearly erroneous, which is a deferential standard, but he still said that based on these facts, it was wrong to conclude that racial discrimination did not occur here, and he ultimately reversed Mr. Flowers' conviction. Now, what's interesting is that Kavanaugh makes clear in his opinion that this is an extremely narrow ruling. He says that in reaching this conclusion, we break no new legal ground. We simply reinforce and enforce Batson by applying it to the extraordinary facts of this case. So he makes clear that his ruling is very limited here. And so, defense bar individuals and also folks who are opponents of the death penalty are going to want to look to this case for some sign that the court might be interested in rethinking Batson, or might be looking at new types of evidence as a way to make the Batson test more robust. And in fact, Kavanaugh makes very clear that that's not what's happening here. And this is consistent with the last 3 cases that the court has granted cert on in Batson cases. They've all been cases that had extremely outlying facts. The court makes clear here that the 6 trials are relevant to the Batson violation, and we all know very few capital defendants are tried 6 times. They've all come from southern states, and they've all had some sort of unique factor, a smoking gun, like in Foster versus Chapman, the 2016 case, where the attorneys actually had the prosecutor's notes indicating that certain jurors were Black and that Black jurors were undesirable. Snyder versus Louisiana, again, it was a specific set of facts where the court was saying, no, these do rise to the level of racial discrimination. But rather than rethinking the Batson test here or doing something new, Kavanaugh was right in line with those decisions. And in fact, he actually doubled down on the validity of the Batson test. He grounded that test in deep historical law by starting with the creation of the 14th Amendment in 1868. He then traced it through various equal protection court cases, including Brown versus the Board of Education. And he spent a lot of time comparing the Batson test to the test that came before it, which was the Swain Test. And the Swain Test was a situation where court said, not only do you have to show intentional racial discrimination, but you have to show it systemically. So looking at an individual strike is not enough. That test was universally recognized to be toothless. And in fact, the Batson court said as much when it overturned Swain and instituted Batson. And Kavanaugh here puts his seal of approval on all of those actions, and lauds the Batson test as a great test to root out instances of racial discrimination. In doing so, he doesn't change anything, but he does re-enshrine a test that most advocates for defense, for defendants and members or opponents of the death penalty have agreed is not a test that's actually preserving the rights of criminal defendants on a wide-scale basis. What this case does, I think, for the court and for the Batson test is that it's an opportunity for a justice like Kavanaugh, who is a conservative justice, whose legitimacy was attacked by the Christine Blasey Ford hearings, to come out in a very, very slight way as being willing to do a progressive ruling. This is a ruling that seems progressive on its face because it's in favor of a death row inmate, but in reality, it's actually quite a conservative ruling that legitimizes a test that most agree has failed and actually also serves to legitimate himself as a fair justice. And you see that in all of the recent Batson cases, that Alito wrote one of these cases, and of course he concurs here, which Kate will talk about in a moment, that Roberts is in the majority. And so these cases are consistent with what Roberts would like to do, which is to portray the court as a nonpartisan entity that is based in interpretation of the law. So I'll now turn this over to Kate, who can talk about Alito's concurrence.
Okay. So yeah, so I was a little surprised to see that Alito had concurred, though now listening to Kathryn talk, it makes a lot more sense to me. I also noticed that this was a 7-2 decision, which, as Kathryn just mentioned, is sort of a Justice Roberts' dream, to show that the court is institutionalist and not political, and to do so in this sort of splashy way, but actually not really change the law very much at all. And interestingly, Alito concurs, just sort of to remake the point that Kavanaugh makes in his majority opinion, I guess a little bit, even a little bit stronger, to say everyone should know how unique this case is. Alito, to my mind, is one of the justices who dislikes criminal defendants and rules against them, almost more than anyone else. So I was, as I said, a little surprised to see. Then reading his concurrence, you can see that he's saying, I'm ruling this way in this case in favor of the defendant because these are 5 trials where the appellate courts in the state had said they were marred by racial bias on the part of the prosecutor. And it's that same prosecutor who's trying the 6th trial in this case here. One thing I'll say is this is a small community. I'm not surprised that the same prosecutor is trying all of the cases. It's not as though they have an army of deputy prosecutors waiting in the wings to try these cases. And I imagine if there's a 7th case, the same prosecutor will try it again, although I guess that remains to be seen. But anyway, Alito goes to great pains in his concurrence to make clear that he's deciding it based on the facts of this case. So not for any defense advocate to be too excited that he would rule this way in another Batson case. So this was, as I said, a 7-2 decision. So the 2 dissenting justices are Justice Thomas and Justice Gorsuch. So Gorsuch and Kavanaugh are now sort of splitting, sometimes Gorsuch ruling in favor of criminal defendants, sometimes Kavanaugh ruling in favor of criminal defendants. So Gorsuch is in the dissent here. Justice Thomas writes a pretty angry and somewhat cynical dissent. The first thing he does is to sort of dramatically retell in grisly detail the facts of the case, which we've noted or have noted already are not relevant. And as someone that I follow on Twitter made the point that it would be very surprising to see Justice Thomas give such a grisly retelling in a police brutality case where he would most likely rule in favor of qualified immunity for a police officer. But he says, upon the witness's arrival, he found a bloodbath. He makes clear that there was one person who was killed, that he was fighting for every breath, blood pouring over his face. So, the beginning of Justice Thomas's dissent sounds like the beginning of a Law and Order episode. But he then goes on to say basically, the court is not disputing that the evidence was sufficient to convict Flowers. Of course, again, the court had no reason to go into whether the evidence was sufficient to convict Flowers. And then he goes into great detail about why the prosecutor's strikes were based on meritorious, non-racial reasons. He claimed in his dissent that the court granted this case because the case had a lot of media attention. That he saw no reason to grant the case because there was no new law to be made, but rather the court granted the case because of the media attention. I don't know if he was talking about the podcast or just other types of media attention generally. And then he questions the basis of Batson at all. So he, I guess, like defense attorneys, doesn't like the Batson test, but for the opposite reason. He's basically saying here, well, Mr. Flowers shouldn't be able to raise this issue because the issue is really about one of the jurors. It's their equal protection. It's the juror's equal protection claim, and the defendant shouldn't be allowed to raise this because it has nothing to do with his guilt or innocence. Of course, many rulings on criminal trials have nothing to do with the guilt or innocence of a particular defendant. But he also suggests that the whole line of cases, Batson should be thrown out. And the only question should be whether the defendant had a fair trial, and that the jury's impartiality should go to that question too, and how the jury selection should also be decided based on that question. And he says at the end of his opinion that if the court's opinion today had any redeeming quality, it's that the state is perfectly free to convict Curtis Flowers again, meaning the state can bring a seventh, try him a seventh time. I don't know if it will, as I mentioned before, that they had a jailhouse informant who's now recanted his testimony against Mr. Flowers. And one of the main witnesses who claimed to have seen him near the store, her sister has now told the government that that woman was actually with her. So the state's case seems significantly weaker, but we'll see if they try this case again. So I guess to me, just under the collar of this case is sort of an ongoing feud again about the constitutionality of the death penalty. As other justices have done historically, Breyer and Ginsburg, sort of now in the later stages of their careers, have started to openly question the constitutionality of the death penalty. I'm wondering, Katie, if you think that, does this case mean anything good for folks who think the death penalty should be ruled unconstitutional, or do you have any thoughts about the court and the death penalty in this term?
Great. Thanks, Kate. And the short answer is no. I think this does very little to change the unlikelihood that the court is in a position to find the death penalty unconstitutional anytime soon. As I said before, this is a pretty narrow case that Kavanaugh limits to its facts. And, when Thomas is calling him out and saying, cert never should have been granted in this case, he actually has a strong point because, as we all know, the U.S. Supreme Court, its function is not to engage in error correction. Mm-hmm. Its function is to make far-reaching legal decisions that impact lots of people or to clear up confusion below when appellate courts disagree about what the law should be. We don't have either of those things going on here. The question that the court granted certiorari on was, did the Mississippi Supreme Court err? Which is exactly error correction. And so Thomas really has a point here that this wasn't an appropriate case to grant cert on. And again, I think it's in line with my conclusion that this is sort of a no-brainer that the court can reverse and gain legitimacy for without actually changing the law in a meaningful way. And I think that this is completely in line with the jurisprudence that we've seen this year. So after Glossop, as you pointed out, Kate, there was a lot of momentum for making Eighth Amendment arguments to challenge the constitutionality of the death penalty, because even though that case did not go in favor of the criminal defendant, in dissent, Breyer and Ginsburg made clear that they think there are a lot of procedural problems with the death penalty, including Batson, including the process of death qualification, which determines who can sit on juries based on their views about the death penalty. And so advocates were optimistic that, Kennedy was on the court at that time. He was typically seen as the swing vote in these issues. So they're optimistic that they could sort of chip away at the death penalty by bringing up problematic cases, putting them before Kennedy, and then ultimately making a per se constitutional argument that the death penalty itself is inherently unconstitutional. Well, all of that changed last summer when Justice Kennedy retired. Of course, before that, we had Gorsuch appointed to the court. And then when Kennedy left, Kavanaugh was appointed. And maybe at first blush, it seems like, oh, well, this is what Kennedy would have done in the Flowers case. So having Kavanaugh in the case, is no different. But we can't look at this case in isolation. We have to look at what else the court has decided this year. And so there haven't been a lot of death penalty cases. In February, the court decided Madison versus Alabama, where it, again, narrowly found, and this was a ruling where John Roberts was in the majority, Neil Gorsuch was in the minority, and Justice Kavanaugh had not actually been on the court when the case was argued, so he didn't take part. But ultimately, the court found here that there's no bar in looking at dementia or memory loss and making a determination that a death row inmate cannot be executed. So they didn't decide the merits of the case for Mr. Madison. They didn't say that, based on the evidence that's been presented at the trial court, Mr. Madison cannot be executed. Instead, they remanded and they told Alabama courts to consider what this evidence was and to make the actual merits determination on the case. That's a really narrow ruling. That's not what they did here. They didn't tell the Mississippi courts to reconsider the case under Batson, where they had to consider the prosecutor's history of racist strikes. They actually decided the ultimate issue here. So much more conservative, in favor of the death row inmate, but much more conservative opinion in Madison. There was a lot of attention brought to two cases that were very similar that involved stay of execution applications. There's the Ray case out of Alabama and the Murphy case out of Texas. In the Ray case, a death row inmate was arguing that a Muslim cleric should be allowed to witness and be present in the execution chamber during his execution. Alabama had said that that's only something that Christian clerics were allowed to do. So Mr. Ray's lawyers asked for a stay of execution based on violation of the free exercise clause, and the court denied the stay. And then about 3 weeks later, a similar fact pattern arose for Patrick Murphy in Texas, only he was Buddhist. And there, the court granted a stay, and Kavanaugh actually wrote on that grant. So he had been in the minority on the first case and now was in the majority. And he wrote, "This does seem like a violation of the free exercise clause." But then he told Texas what to do about it. So he told Texas, there are two things you can do here. You can let everybody, any sort of religious cleric in the execution chamber, or you can let no religious clerics in the execution chamber. So I think we can all guess what the state of Texas would choose. And so again, even when it seems like the court is ruling for the death row inmate, it's in a very limited way that either makes an exception for an individual or makes a declaration about the law, but then cabins relief for that individual. And so unfortunately, as a member of the defense bar and an opponent of the death penalty, I would love to find something new in Flowers. But even the analysis that the court did at looking at disparate questioning, at comparing jurors who were struck to jurors who served, that's all stuff that we've seen before by the court. It's good that that's still good law, but the court really missed an opportunity here to actually get at some of the problems of the Batson test and to rethink that test. So as an example for what the court could have done, we can look at the state of Washington. That Supreme Court, based on state law, has decided to evaluate Batson claims based not on intentional racism, but instead based on unconscious bias, which is what we know predominates all of our institutional interactions. And there, the court came up with a list of proxies for racially discriminatory strikes. So things like, lives in the same neighborhood as the defendant, or, has negative feelings about police officers. Those are all proxies for racist strikes and are now forbidden by the Washington State Supreme Court. So that's something the court could have done. Of course, we don't really have expectations that the US Supreme Court is going to rewrite the law in that way. But we also don't have expectations that they're going to correct errors for individual death row inmates, which is what they did here. So I am a little bit cynical about the value of this case to anyone more than Mr. Flowers, although I am also certainly happy for Mr. Flowers. I did want to just fill in one thing about what could happen next. And because there's a little bit of a discussion about this at oral argument, when Alito sort of in saying what he says in his concurrence more glibly was kind of like, I don't understand why the same prosecutor keeps trying this case. Kate makes a really good point. This is a tiny town. There probably aren't a lot of options. But in Mississippi, there's actually an option for intervention by the Attorney General. And the problem is that by statute, that can only come at the request of the prosecutor. And so Doug Evans, who, as chronicled in the Dark podcast, clearly has a vendetta against Mr. Flowers, would have to give up his power and ask the state attorney general to take over the case. Alito, in his concurrence, it's kind of like, if you do that and you get the exact same result you get here, nobody's going to overturn that as a Batson violation. You will have more freedom to strike African-American jurors if you have a different prosecutor and a different county. So it remains to be seen whether or not Doug Evans will be smart enough to, and will lack the ego. Of course, it takes a lot of humility to give up a case, particularly a case where you are clearly very personally invested. So it remains to be seen what Prosecutor Evans intends to do. All right, Kate, any more thoughts?
Nope.
All right, well, this has been Cardozo Law, unboxing the U.S. Supreme Court. Thank you so much.
Thanks a lot.